sincerest apologies for what you are about to see. It's been a real bad tech situation tonight. So it's terrible quality. I ended up having to like screen record the stuff that I recorded, like of me, and it's just not been good. So yeah, look, I'm really sorry about that. And then I think the end of the slideshow kind of just like, I don't know, mid talk, and then just like fucking trails off or something. I don't know. Yeah, apologies. But look, the content's in there, the stuff's in there that you need to know. Just yeah, it's not gone very well, but we're fine. We're all good. Cool. So fingers crossed it uploads okay. Alright, thank you. Hey everyone, this is part two. Going to try to get this done relatively quickly just because I'm running out of time for today. I wanted to quickly point out as well, not that I really need to, for those that don't know, I have clearly got autism and ADHD, so that's why I really struggle to look straight ahead, especially when I talk about it. So now I'm looking like I'm having some sort of seizure or something, but yeah. So something I'm working on, but that's why. So I just wanted to sort of explain that for anyone that didn't know. Okay, so today I'm going to be going through family violence orders. There's going to be a little bit about like bail conditions and like conditions on the order and like the differences and stuff like that. I may sound a little bit robotic just because like there's a lot of this that's quite relevant to me that I need to like detach from a little bit to get through this. Just otherwise my personal thoughts could, get involved, and obviously that's not ideal. Again, this isn't legal advice or anything, so just disclaimer there. And at the end, I've got some support numbers and details for both sides, both victims and for the perpetrators as well. So I'm just going to get through this. This is a slideshow again. I'll just go through that and then check back in with you after. Hello. Okay, so I believe this should hopefully work okay. So we are looking at family violence orders. And okay. So we'll just start basic. So what an order is a legal order made by the Magistrates Court to protect victims, survivors. It sets conditions and respondents must follow. Breaching an FVO is a criminal offence. So that's the very, very, very basic idea of what it is. Okay, so this is where we get into the difference between the two and what's going to be better. So there are pros and cons to both, I will say. So the pros, immediate protection, no need to appear in court initially. Police manage evidence, which can be a pro. Cons, survivor may feel excluded. Conditions may not fit needs. Police can withdraw without input. The self-initiated is, so pros are survivor has more control, covers cases where police don't act. Cons requires court appearance, may face cross-examination, intimidating without support. So the big question is which option is best. This is a very, very, very case-by-case basis, but I personally I don't know. I literally just changed my mind in my head just then when I said that. I don't know. Look, if it's a really urgent, obviously, if it's an urgent, life-threatening situation, it's always going to be best to call the police. They can obviously attend, and then they do have the power to initiate the order if they believe that they need to. Self-initiated tends to be very difficult obviously for people to get the courage to do it, and then also to have the evidence required for it. However, please don't let that deter you. So say you've been through something that you haven't reported, you can still do that. Like, you can do that now. I believe it's about a year now from when the incident occurred that you can report it. Obviously, if it's ongoing, then you can report multiple instances as well. Both are valid and can be changed or varied as circumstances shift. Okay, so this is an idea of what a self-initiated looks like. So the first step is you go to the court registry or download the form online is probably your easiest way. Step 2, fill in the abuse details and reason that you need the protection. Step 3, include evidence, photos, text, witnesses. And I will say I believe that you need to have those potentially signed off by a JP, maybe. It'll have all the details on there, whether you do need to do that or not. But obviously, like, then when you submit it, it needs to go in with the stat deck, which it says down there. Sorry, skipping ahead. So you lodge it. So you go down to court and then give them the paperwork. They will set the date then and there for the next, or for the hearing, or for the next hearing. And then step 5 is obviously the final hearing date when that comes around. Now, the little bit that I've got at the bottom is about the interim orders. So this is only for self-initiated. So obviously police initiated a lot of the time when they are initiating it, it'll automatically be an interim order because, for example, say they've arrested someone and they've served that person with it, that person then has to go and front a magistrate who will then have it as an interim order until it becomes finalised, because that can potentially take a very, 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 very long time for it to be finalised, at which point it's usually about 12 months, I believe, but you can get longer or you can extend it as well. But yeah, like at the self-initiated with the interim, it's a little bit different, obviously, because the police aren't initiating it. So if you go to court and you say, here's my paperwork for this, this is a really serious issue, they can potentially get a quicker date for it to be heard, like with you, without the perpetrator there, potentially, this is all just in theory. Then obviously if they hear that application and they believe that you're in immediate danger, the magistrate can make the interim order straight away, at which point, they still have to investigate. So, it's still going to be innocent until proven guilty as well, because they, rightly so, need to give the other party the ability to have their say. They, need to offer them an interview so that they can go through what's been presented as well before actually charging anyone per se with anything. So there's obviously a few different trails that this can go down. Trying not to get a little bit carried away with each one, because I know that it can get really confusing. But essentially, at the end of the day, with a police initiated one, you don't need to, in theory, you wouldn't need to worry about a lot of that, because it'd be taken care of for you, in theory, if the system is all good and works well. But with your self-initiated one, which does have to happen a lot, because let's face it, there's a lot of, cases where we may not feel confident enough to report anything and no one else has seen it. It's not as black and white as people think it is. If it's a self-initiated, then yes, you would go down, you would say this is the severity of it. As soon as you get that date for the hearing, even if it's fast-tracked, it still could be a little bit. So obviously stay safe during that period. That's also another thing to mention. Have a safety plan. Try to stay with friends, family, whoever you need to, just during that time before the hearing, if this is your situation. And then with the magistrate, if they can get an urgent one to be heard, then that's, yeah, you would potentially hopefully get a magistrate that would be able to approve an interim order, and then, you know, on the basis of let's come back to this when this person's had a chance to go through, you know, the evidence and everything, and then they wouldn't instantly just charge. So a magistrate can't just like charge someone on the spot and be like, oh yeah, like I feel like that person's, I feel like you're right and that person needs to be locked up. Like, you know, go get him. Like that's not how it works. It's a little bit of a crossover, but I will go over that now in a minute. So first, so varying an order is also a little bit, it's similar, but it's really only, I'm just trying to think of how to say it. It's just case by case, and I hate it when people say that to me, but it's just true. It's case by case. This is just whether it's police initiated or self-initiated. So say that the order is either finalised or even an interim order, and you're waiting for your hearing date or whatever, you do have the ability to put in a variation. So this is the, excuse me, sorry, this is the rough steps. I've just tried to break it down as much as I can. Okay, so the first thing is you get the application form, similar to when you lodged it, but it's called like a variation one, and it's got like family violence or police initiated family violence, because those are obviously two different ones. You will need to make sure you get the details of the existing order, which shouldn't be too hard. With the interim order, you should be sent a copy of that by court support. The police may send you a copy as well initially. If you don't have it and you need it, don't stay quiet about it. Like, definitely just give them a call, because, you know, they're very snowed under. They've obviously got a very high workload as well. They do the best that they can, but you definitely need a copy of that order, especially if you're going to then need to use that as evidence yourself for, you know, personal life things. So my first thing to suggest would be to call court support and ask if they can get a copy of that, remembering that it's not like instant. Unfortunately, again, you know, workloads, they do the best they can, but it can take a week or sometimes more to get a copy of that order, even if it's an interim order. However, it is like, it's active from when it's set. So if the magistrate says, yes, we're doing this, it's from that second. So just to clarify, you don't have to like wait a week or so until it becomes active. So you complete the form, fill in your details and the respondent details, clearly state which conditions you want changed, for example, adjusting contact restrictions, access to children, changing residence requirements, explain why the variation is necessary for safety concerns, change circumstances, ongoing risk, for example. Prepare a stat deck if required for self-initiated applications. So I've not had to do that part of it, but I've definitely done a stat deck before. All of the stuff, like if you go in and get the form, you can always go and ask to clarify as well with the magistrate's court. Like if you need to just, yeah, or call them, I guess, like just ask the question if you're not sure. Or I've done a few of these now, so like if you guys want to get not legal advice, but if you just need some guidance, I'm happy to try to help out. Or of course you can call legal aid, or if you've got a lawyer or whatever as well. It's just, I know it can be extremely overwhelming, and a lot of people, myself included, like, you know, it's when it gets overwhelming, it's a lot, and you don't want to necessarily tackle it by yourself. It's always a good idea to just be with someone or try to get someone to go with you if you can. It just makes a big difference. The evidence. So you need to make sure you've got any evidence if that's applicable for variations, which, I mean, I guess, so what, text, affidavits, support letters. I guess like this would probably be most relevant in, I mean, obviously if that person's breached, you would have reported them anyway, so hopefully the conditions would change. But if not, if it's sort of like a contact with kids type situation and you're trying to change the protections to get them to have the ability to see them, for example, you need to sort of be able to provide reasons as to why you should be doing that, because at the end of the day, like, the way that the law sees it is, in theory, the way they see it is, we've put this in to protect you, why would you want to change it? However, reality is obviously very different when you have children, particularly when you need to have the other side potentially with the ability to reach out to the children. There's also, like, in the actual order itself, there will usually be like a clause in there for a no contact, where they do have the ability to reach out to mediate, like whether that's through a lawyer or whatever. They can definitely call Relationships Australia and ask, you know, basically, how can I talk to my kid? How can I see my kid? There's always going to be a way to do it. So that's really just to let you know. You don't necessarily need to go and try varying the conditions of the order, because that could potentially backfire. So what else? What was I up to? Yeah, so police initiated orders can only be varied in limited circumstances and usually through police. So I can tell you, for example, myself, I had a variation done early in the piece to allow the other party to go and collect items from the house that we were in before, because I was trying to sell it and obviously wanted to give him the ability to get his stuff. So I was able to go through the process to add in sort of like a one-time instance where he's able to do that. And forms of communication and stuff as well, like you've got, you can say there's like stipulations where it's no contact other than, you know, through a legal representative or through electronic communication. I will admit that I personally I thought that it would help if I would adjust it slightly to allow like the electronic side of it, but really it didn't make any difference. It really just sort of created more stress, I guess. So just really have a think about what you need, and also remembering in theory that this should be for 12 months, which is an exceptionally long time when you've got kids. I understand that, but at the same time, you know, it's a good chunk of time to give that other party, you know, a chance to try to fix whatever they have to fix. Again, I know it's not that easy though. So step 4, you file the application, lodge the completed form at the Magistrates Court registry. There's no fee for family violence order applications. Step 5, Magistrates Court will set a date for a hearing. So this is very similar to when you first lodge it. The respondent must be served with the application so they know about the variation request. Okay, so this, again, there's just like a few gaps in the process. Like, I feel like it's important to mention that they've come a long way, and I really am very incredibly grateful for a lot of things, but there are just like a little few bits and pieces that really need to be worked on, and this is potentially one of them. So going into request a variation, if you don't have legal representation because, like, you know, money, they don't actually often approve legal aid for all scenarios. Like, even if you're the victim, sometimes they will, sometimes they won't. So, I mean, in my situation, for the first time I was able to get representation, like there was like, it was for a variation, and then I think there was another one later to do another variation that I had to get a different one. Anyway, tangent, sorry. Basically, when you go down there and you lodge the form, the other party has to be served. Like, that's fair enough. Like, they need to know what the hell's going on, and obviously there's a date set, and it's not a date they're already coming in. Like, they need to be told that, so that they've got the right to come in and defend themselves. So, but to serve it, obviously, if someone's got an order to not go near you, and you're meant to serve it, it's sort of a little difficult. They don't always think about that. So my advice is to find out who the lawyer is for the other party. They will more than likely have representation. Legal aid is commonly given. Like, if they're arrested for something, they will just automatically be given a lawyer, is my understanding. So I could be wrong, but that is every single case that I've ever spoken to anyone about. Same thing. They are big. I mean, if you think about, like, they have to be given the chance for legal representation if they're charged with something. It's just the way that it is. We potentially have to fight harder for representation, as backwards as that is. So they have to be served with it. So I would recommend to see if you can find out who the representation is on behalf of for the other side. Try to get hold of that lawyer and deliver it to them. They can accept it on their client's behalf. Otherwise, you will potentially have to get somebody else to go and serve it to the person. You can, like, pay someone to do it. Again, I don't think that's really fair for the victims, but it's just options that are out there. So just bear in mind, like, that could potentially be a hiccup. At the same time, if you have a support network, a good support network, any support network, you should be fine, because I'm sure someone will be willing to assist you with that. It's really more for people that just have absolutely no one to help them. Okay, step 6 is the hearing. At court, both sides may be heard. The magistrate considers whether the variation will continue to protect the safety, well-being and interests of the affected person and children. This is the part where it really is good if you can get a lawyer to speak on your behalf, because it's obviously quite overwhelming, especially being in the same room as the perpetrator. The magistrate can vary conditions, revoke the order, or leave it unchanged. The final decision is in the hands of the magistrate. So they make that final call. This is, again, with self-initiated ones. Police-initiated, different. That is about the prosecution. So that one is, can be quite frustrating at times, where it kind of goes back to that part where it said the differences between the two types, and you can be left out of a lot of things. Basically, you can put in a variation request. You've done that, you've made that request, but then you don't actually get a say in anything, because it goes to the prosecution, and then they decide whether they're willing to negotiate with the other party's lawyer or whatever. That was an extremely big frustration for me. So that's just something to bear in mind. But with the self-initiated one, obviously, like, the magistrate's more likely to be able to talk to your lawyer or yourself about this and say, well, why do you need this? And then make that decision based on that. Step 7 is enforcement. Once varied, the order is binding in its new form. Police are responsible for enforcing breaches. Any breach remains a criminal offence. So, like I said before, from the second that you walk out of that room, whatever the magistrate says goes. Even if you don't have the confirmation in writing or whatever for a little bit. Okay. So conditions that can be included. Possible conditions under the Family Violence Act. All right, so this is just a very, very, very basic, brief, vague, list. Usually it's quite bigger than this. All right, so no contact by phone, text, email, or in person. It could also be one of those things. It could be two. It could be all. It could be many different things. Must stay a set distance away. This is probably the most common one, obviously, for an order. The idea is to protect people. So example, 100 metres from the home, work or school. Vacating the home if shared. So that was one that I went through, but I guess, they're not just going to, chuck someone on the street either. Like they need to make sure that they've got somewhere to reside that's not at that house. But that sort of comes into some stuff I'll go through shortly anyway. Surrender of firearms, ammunition and licenses. No stalking, harassment or intimidation. Again, very broad, that is. It does break down, if you look up like the actual definition of stalking, it's like there's lots and lots and lots and lots of different things in there. So it's not sort of just as simple as it looks right there, written there. No damage to property, pets or vehicles. The pets thing, I think I mentioned yesterday, is relatively new where it's been put in there. So that is now a criminal offence as well. Excluded from certain places, schools, workplaces, technology restrictions, no online abuse, tracking, sharing private info. I've not actually seen that one before, but I think it's kind of like the no contact one, because you wouldn't be able to, contact, if it says like no contact via any forms, like by any means, then I suppose that would cover that as well. Breaching any condition is a criminal offence. Okay, so police obligations in Tasmania. So this is what should happen. I say should because it doesn't always. So this is in theory, in a perfect world, like which we're not in, obviously, this is how it would go. The police would arrest the perpetrator if they believe that family violence has occurred and that there's a danger. The order can be issued on the spot to provide immediate protection. That's interesting, didn't know that. Arrest ensures safety and accountability. In practice, this does not always occur, but it is what the law intends. Okay, sorry, just struggling to get through this one a little bit. So, yes, so this is applicable for when you put in an order, like if you go in and you make a statement or whatever. Or also if there's like a breach, and it's difficult because I believe the wording that they technically are meant to go by is if there's any danger to, imminent danger to you or your children or whatever, or others. So in theory, a lot of the time it doesn't happen when it potentially should. If it doesn't, what happens is they give them a summons. So they should, in theory, if they go along the summons path. So say someone has reported a breach, and then you've given your interview about your side of events and evidence. So you really need to try to make sure you've always got the evidence. Unfortunately, that doesn't always make a difference. But they will then go to the other party. They will interview them, so invite them in for an interview to go through the accusation, I guess, and evidence, and then they will either arrest them, take them in to remand, and then they will face a magistrate the next day or that day, or they will send them home and give them a summons, or tell them that they're going to get a summons, and then just send them home, and that's it. And then they will receive this summons, I think, in the mail, like within, again, the time frames are just all over the place sometimes because we don't know. But for example, one that was done by myself in May wasn't actually given until like July. So it can take a very long time. There's a lot of different moving parts there where they've got to do that summons as well. The frustration obviously is if they had just arrested somebody and put them in, then it would have been a lot quicker for everyone, really. And it's more instantaneous sort of when they see the magistrate, plus obviously like the protection and the peace of mind of them not being out and about. It's helpful, obviously. Lost my train of thought there. Sorry, I was going on a million different things in my head. Okay, going to move on. Sorry. Difference between FVO conditions and bail conditions. Okay, I put this up because I found it really interesting. I am a nerd, yes, but it's because I researched the crap out of all of this, and they are different and they are very confusingly different. So here is a few examples. The difference between, so the family violence order is set by a magistrate when you apply for the order. So like I said, you go in, you do the application, you've got a hearing date, you go in, they then make a decision. That's if it's self-initiated or police initiated. Remembering there is the interim order as well, just saying. That's not the final order, but either way, like the conditions, so the police, like if it's police initiated, the police will usually work with the family violence unit to say, this is what we would like, or these are the ideas that we've got, and then it's up to the magistrate to make that final decision. So whatever's written on that piece of paper is the magistrate's decision. So it can include stuff such as no contacts, must not come within a certain distance, must vacate, must not harass, intimidate, stalk, must surrender firearms. Purpose is to protect your safety and well-being and children's. Breaching an FVO is a criminal offence. I know we pretty much just went through this. Bail conditions only apply if the perpetrator has been charged with a criminal offence. Okay, so this is after, say, it's really, most commonly you're going to be seeing, obviously, bail conditions if there's an incident and then you report it and then that person gets arrested and then taken away, because that person will then be taken to remand in theory and then likely be bailed the next day, or the same day, and then that's where the bail conditions come into it. So the bail conditions are set by police initially. So this is the part that I get confused about. That's why my wording is not great here, because I'm just trying to think of how to say it. It's set by police initially or later by the magistrate at a court appearance. So I guess, well, then the magistrate's not going to just be like hearing an application and then be like, okay, well now you can have some bail conditions. Like, it doesn't work like that. They have to be charged. So there has to be, it has to be founded that this has happened, or there has to be evidence given, and then they get charged. That's when they would be given bail conditions, if there's actual criminal charges. So it's possible to get an order and not actually have any charges laid, just have it like a protection order, I guess is the best way to say it. A part of criminal procedure law, so that is the bail conditions. This is where it gets confusing. It's more of a civil for the family violence order and a criminal for the bail conditions. The conditions should often mirror or strengthen FVO conditions, such as no contact, required to reside at a specific address, curfew or movement restrictions, regular reporting to police, electronic monitoring. In development for family violence cases, I've got that there because you'll usually, in most cases, find either it happens like very quickly, or it never happens. That's usually the way it goes. It's a bit of a touchy one, that one. So the purpose is to manage the accused while awaiting trial and prevent further offending. Breaching bail is a criminal offence and can lead to arrest and being remanded in custody. So that's where I say could be, or they could just give them a summons. Really, I know that I won't say I know because I'm now second guessing myself, but I'm fairly confident that in maybe New South Wales, automatically, if there's an order that's been breached, they automatically have to arrest them. I think, but I could be wrong. I will check that because if he ever gets back to me, my friend Jay, who did stuff in New South Wales for Family Violence Unit, I think, he said that he'll do an episode with me, which is very exciting. So he's got a lot of knowledge, and I'll be able to confirm a few things then. Okay, bail conditions. This is, yeah, so I've just put this in here again because you don't really see this. This isn't going to be showing on an order. This is going to be only for the perpetrator's eyes. But court support can tell you what the bail conditions are, just so you know. They are able to let you know. So usually if something's happened and, you know, that person's been locked up or whatever, and then the next day they get bailed, you'll then get a call from court support and say, okay, this is what's happened. These are the new conditions or the current conditions or whatever. This is the new date when the hearing is. That's an example of how it works. So these are, yeah, the potentials of what could happen for bail conditions. Obviously, severity is differing in a lot of those things. I'll just quickly go through it. So no contact, obviously, no direct or indirect communication must stay. Now, just so you know, this is going to be on the order, like more than likely you'll have a no contact on there, which means that if they breach that, as in they breach the family violence order by making contact, physical or otherwise, that is automatically a breach of bail. So that should then be a charge for breaching the order and a charge for breaching bail. So because it's already on there. I guess this is more just to say in a different scenario, maybe where there's no order and it's just maybe someone, I don't know, some rando from like tried to rob a banker, I don't know, like whatever, like gets arrested for something else, and then that's just one of their bail conditions. I'm just saying that could potentially be on their bail conditions for whatever reason. Required to reside, restricted movements. Must live at a specified address, may be subject to curfew or movement limits. I won't go too much into that again, but pretty self-explanatory. Reporting to police supervision, so must check in regularly with a police station or bail supervisor. Again, not sure how common that is. I don't think that that's very common at all. I think that's probably more probation that would be a thing. But again, yeah, only speaking of experience. Financial security / surety. Deposit or guarantor to ensure compliance. So yes, a surety is basically someone's gone in to bail someone out and they've said, okay, well then you need to be, you know, this person needs to come with you every time you have a hearing. That person needs to be there. You need to reside with them. Usually they, in theory, have to pay a fee if that person ever breaches, that sort of stuff. Mandatory program participation, may be ordered to complete a behavioural change or rehabilitation program. Yes, again, more likely to be a probation, like a condition of probation, not bail, because usually that would be if they're, you know, guilty or whatever. Yeah, as part of sentencing. Electronic monitoring, pretty self-explanatory. I don't think there's really anyone that doesn't know what that is. Ankle monitor, basically just slaps around your ankle and they can track you. So these are all the potentials. All right, so I've just got a few frequently asked questions here just to slowly wrap up this. It's just important that we talk about it because it's, yeah, a lot of people ask this to themselves but are too scared to ask other people. So it's just, yeah, I want to go through them. So is it abuse if they've never hit me? Absolutely, absolutely. Abuse can be emotional, financial, sexual, controlling. It can be many others as well. Go back and have a look at the first part if you haven't already. Just have a look at just an example of a few of them. There's a lot. So please don't ever think if it's not a smack in the face, it's not abuse, because that's the biggest myth out there. And I think luckily our system is coming to realise that. What if I still love them? I don't actually know why that one's not in italics. That's my bad. It's common to love someone who hurts you. Of course you're going to still love them. Like, it's not, again, it's about the trauma bond. Honestly, I could talk for days about trauma bonds. It's not as easy as like, oh, they did a bad thing, you don't love them. I mean, what if your kid did a bad thing? Would you be like, yeah, no, I don't love you anymore? I mean, like, that's a bit harsh. That's, yes. Anyway, just scraping the surface of that one. It would be bizarre if you didn't love them still, just because of this particular incident. You've obviously stayed for that long for a reason. So, yeah, just don't, when people say that, it's weird, or if you ever hear that, just, like, smack them in the face. No, just don't listen to them, because that's not true. Trauma bonds are a real thing, and I really wish there was more education about it. Why don't they just leave? Another one. Ugh. Leaving can be the most dangerous time. It is the most dangerous time, I reckon. Leaving and then sometimes even then going back and then leaving again. And yeah, look, there's many articles, videos, documentaries, lots and lots and lots of things out there about why leaving is the most dangerous time. It's not that simple. Anyone that asks that question needs to do some research, in my opinion. How can I stay safe if I can't leave yet? Keep an emergency bag, a code word, exits. So this is about safety planning. I do want to go through a safety planning video eventually as well. I'm just trying to think of how to do it. The only reason I haven't done it yet is because I'm trying to think of how to do it safely, I guess, because obviously anyone can look at the video, and it's important that certain things aren't released to the public. So I'm just thinking about how to do that. I might put together something separately that I can then send to people. Maybe, yeah, look, that said, you've got all of your supports as well, like your support lines and stuff that I'll show you in a minute that can go through all of that with you as well. But I feel like everyone has a different idea as well for safety planning. There's some stuff that's really creative that you may not have thought of. So that's to be continued, that one. What if they promise to change? They will. Real change takes responsibility, long-term help and accountability. So they absolutely will promise to change. There will probably be many different phases. There'll be, like, you can't do this to me, and there'll be like I love you more than anything. There'll be I'm going to off myself or whatever. There's just so many different things that will be attempted, and this is a huge one. The only advice I can really give is look back on the relationship to when things have gone wrong in the past, and you've set a boundary, or you've said, look, this can't happen again, and then it does happen again. Anytime you've really set like a goal or like an ultimatum, if you've had to, just stuff like that, and they've like, have they done it before? Because if not, then what's to say they won't now? They're just obviously scared if you're at this pointy end of it, like if you're leaving, or if they're obviously scared, and so they're going to try anything they can. But at the end of the day, it's them that's put you in this position, and do not practice as I preach, because I really struggle with this myself in my head. But to anybody else, I will say it until I am blue in the face. Like, it is not your fault. These people have put themselves in this situation. You never asked for it. You likely tried to help as much as you possibly could. You likely let it go on for quite a lot longer than most people would think that you should. Again, case by case basis. But at the end of the day, 10 years ago, if you didn't even know this person, I don't know, you wouldn't then be in this exact position right now without meeting them, if that makes sense. You haven't done this. This is not the course of events of your life that were meant to go this way, especially if you've got kids. This was never the plan. So anyway, sorry about that little rant. What if I'm worried about my kids? Okay, children are always affected. You should be worried about your kids. Kids should always come first. That's actually quite difficult a lot of the time to put, not to put the kids first, but in your mind, you will feel guilty a lot for having thoughts of missing that person, especially if the kids are struggling with it. That's a double smack in the face. But it's kids, you always have to do what's best. And again, one piece of advice from personal experience is look at how they are from, like, it's a struggle. It's never easy to get through any of this. But if you say, take it from like a couple of weeks after the, the big legal stuff starts, and, or like they can't see that child or whatever, just a couple of weeks, even, and then more like probably preferably more like a month, because there's a lot of shock and stuff involved. Have a look at your kid and genuinely think about how they are on that day compared to the day that you left. And I can almost guarantee you that they're going to be better off, in whatever small way that might seem. And it doesn't actually become evident until it's been a bit more time. But try to stop beating yourself up for missing that person every day. I mean, it's what are we, September? So 9 months ago, this all started, like the big stuff for me. I'm no better. Like I still have those thoughts every day of like missing him. Like it's insane. And then I get mad at myself. So just please don't beat yourself up over that. Like at the end of the day, like you're doing the best that you can do. This is the kind of stuff that I am here for specifically. Like if you want to talk it through, like I've been there. I can help with at least being a sounding board. If you just need to vent, if you need some advice, if you just need someone, like it's so important. I had no one for such a long time. I'm only now just like starting to make some connections, and it's been 9 months. So yeah, worry about your kids always, but don't forget about yourself, because at the end of the day, they need their mum to be there still. And if you're driven to insanity and then you're, for whatever reason, not around, like that's not going to help them. They're no better off than, again, preaching to the converted here, but it's true. Like, what's going to happen if you're not there? And don't think that that's me trying to say, how dare you feel this way. I think this is going down a whole different like topic now, but you know what I mean? Like I get it, and I'm here if anyone wants to talk about it, because that's all completely normal feelings. And just remember to think about yourself as well as your kids. And if you're ever unsure, like, oh, maybe I should have stayed or whatever, just look at your kid and just see the progress that they've made since leaving. And I can guarantee that'll help get you through one more day. Okay, here are the support services for help for victims. I think the Family Violence Counselling and Support Service, I think maybe on a previous video, I think I may have had 24/7, because I think that's where I got it from. It was saying that, but that's not true. So I just wanted to point out the hours here. So it's 9 a.m. to midnight weekdays, 4 p.m. to midnight weekends and public holidays. So just bear that in mind. But 1-800-RESPECT is 24/7. I know that much. Okay, I have put this up there. I thought about it a bit, and then I put it up, and then I took it down, and then I put it up, and took it down, and put it up. And I think that it's just important that we have this up here, because at the end of the day, we can't. I really hate the mentality of, oh, well, that's just who that person is, and there's no hope for them. That's bullshit. Sorry, but like you can't go through life thinking, you can't give up on people. I mean, if we gave up on people, we wouldn't have gone as far as we did. And I think that makes us stronger, not weaker. I can feel another tangent coming, so I'm just going to try to draw myself back here. But I believe that everybody deserves help. We can't force anyone to get help, but we can have the resources available to provide to people, so that one day, hopefully, they will wake up and say, oh, I want this, and they will, here's your tools to do what you will with them. Hopefully one day you will want to use them. It is important. Also important, if you are, like, there are scenarios where people are with perpetrators who do want to change and want help but don't know how, are ashamed, understandably so, like just how we can get ashamed, they get ashamed as well. They genuinely don't know where to start. So I wanted to put this up here in case anyone needs to screenshot it or whatever. Like, just know that there are options out there. I think it's important we know that it's not just a lost cause. There's also a whole bunch of stuff potentially, in theory, from like sentencing as well that can then be provided, but that's a story for another day. These are just really important for people to note down, especially if people haven't quite been able to escape yet. If there's potential that you think that your partner might be open to this, just have the options there in case. Don't force it on them because it could just potentially, create an explosive situation, but it's just good to know. So Men's Helpline, No to Violence, Relationships Australia is great for stuff to do with obviously like kids and stuff. I'll just say that Relationships Australia is the contact for perpetrators who have been charged and don't see their kids. That is the number that they should be calling to like initiate a mediation. So a lot of people think it's such a huge, like massive thing, like, oh, I can't go down that road, and if they've got an order or whatever, it's actually not that hard at all. You just make a call, they do an intake, like it's quite straightforward. So that's those numbers. Okay, so it's been a fucking nightmare trying to get this done. The first part of me talking from today, like all formatted funky, so it was all jittery and shit, so I'm just gonna put like a little bit at the start just before that to be like, oi, like sorry for what you're about to say. And then the end part that, oh my god, I went for like, I don't know, 5 minutes or something, gone, like just wouldn't open at all properly, and yeah, so I'm pissed off for many reasons. Today's just not been very good. Anyway, so it's now 10:05. I'm about to upload this. I'm so sorry that it's taken so long, but hopefully it'll still help the video. I actually have another video I was going to do many hours ago, just a real brief one, like a short maybe or something. I'm just pissed right off right now. Some shit's happened in the last like few hours, and I'm just really fucking angry, so I just needed to vent, I guess. But it's not going to be a long one, and I don't know if it'll be tonight now, because there it is. I am wrecked. Okay, I'm going to upload this now. I'm also putting together like a little bit of a different intro and stuff, and just changing up like the branding a little bit for the podcast. Not sure why that's even relevant or important right now, but just thought I'd let you know. If this one doesn't work, I'm gonna have words. Alright, thank you for watching. Please like, share. The next episode, I'm not sure if it will be or not. I've got Jay, my friend, who hopefully will be on doing an episode with me, about his experience in New South Wales force, like police force, doing family violence stuff. I've also got a couple of people that have reached out to me with some pretty exciting, I guess, I don't know if that's the right word, ideas. I'm going to meet up with and stuff, so I think this is working. Please do keep watching and liking and sharing, so that we can get the word out there, and thank you again for watching.